is similar to that of a regiment commander, and he is not of any higher position or a minister of any ministry. In contradiction, Dutch only had a role similar to that of a commander of a regiment. And how many people in one regiment is uncertain. The actual number of soldiers within the regiment is always unclear. However, based on the testimony of those before the co-investigating judges, that the staff of I-21 comprised of those from Division 703 of NAP, and there were about 300 of them, and from M13 about 10, and some forces were led by Camera Sok. In addition, according to the document regarding the forces at I-21, there were a total of 2,327 workforces under I-21. Even if Dutch raised the issue that Dutch was at the lowest rank, Dutch supervised the effective operation of I-21. As chief of that security center, with its powers throughout the country and with specificity that no other prisons had. And the co-investigating judges, as well as the co-prosecutors and the trial chambers, all had the view that he falls under the jurisdiction of the ECCC as a person who is most responsible for crimes committed from 17 April 1975 to 6 January 1979 as chief within the framework of I-21. By considering all the facts and the specificity of I-21.
Before the trial chamber issued its judgment on the 26th of July 2010, the trial chamber had conducted the proceedings, including the initial hearing where parties were allowed to raise the matter of preliminary objection as set forth in the internal rules. The full substantive hearing lasted for 6 months, starting from the 30th of March 2009 through the 17th of September 2009. Parties had 3 months to make their oral closing statements, and the final hearing was conducted on the 23rd of November 2010, and the judgment was pronounced on the 26th of July 2010. Dutch was arrested and sent before this chamber on the 31st of July 2007. He himself and his lawyers had been participating in the procedures before the co-investigating judges, including participation in the questioning of the accused, the reenactment at the killing fields, Act, and S21 vicinity or dual slang, and the confrontation or adversarial hearings. These procedures were conducted following the more than 1 year of investigation. And finally, the co-investigating judges issued a closing order on the 8th of July 2008. Through the entirety of the investigation phase, the defense counsel for the accused failed to submit any request for investigative action on the determination of personal jurisdiction over Dutch by calling Nguyen Chia, summoning Nguyen Chia as the person who was superior than Dutch. although the defense claimed that so in their submission. Further than that, during the procedures or proceedings, especially during the initial hearing, the defense counsel could have raised the matter of preliminary objection on personal jurisdiction rather than on the statute of limitation of the Penal Code of 1956. Also, the defense counsel, the national and international defense counsel acknowledged several facts proposed by the prosecutor that the accused himself also acknowledged the responsibilities of crimes committed at S21. It is therefore the defense counsel fails to exercise the right to make sure the accused exercise his right properly from the very beginning during the investigation phase, as envisaged in the internal rules, and also before the Supreme Court chamber. Because according to the rule, parties are allowed to raise preliminary objection during the initial hearing. Before us today, during this Supreme Court chamber, the preliminary objection is the subject matter for discussion, and the matter is about the personal jurisdiction over the accused, which is against the internal rule. Therefore, the prosecutor would like to request that such a submission be rejected. Defense counsel for the accused maintain its position concerning the interpretation of the message of Rule 87 and Rule 89 of the internal rule. According to Rule 89, the preliminary objection matter shall be raised during the initial hearing. And according to Rule 87 of the internal rule, parties are allowed to present evidence during hearings in order to ensure that the accused is acquitted. Defense counsel must prove or must produce the exculpatory evidence as charged in the closing order or the judgment of the trial chamber, not raising this after 9 months after the proceedings of the trial chamber. This really has harmed the harmony of the internal rules of the ECCC. Above all else, the defense counsel made the final conclusion in relation to the preliminary objection by referring to the practice at national level. This is not correct, because the defense counsel made the final submission, but in their submission they should not or shall not make or raise any matter of preliminary objection, as according to Article 344 of the Criminal Procedural Code, which states that preliminary objection shall be raised during the substantive hearing, otherwise it shall be rendered inadmissible. The defense counsel in their appeal brief also raised the matter of the law outlawing the DK group. This morning, their position has been reiterated concerning Article 5 of the law on the outlawing of the Democratic Cambodia group. In its appeal brief, paragraph 5, it states that the law allowed the Khmer Rouge soldiers 6 months to surrender and come to the to integrate with the government. The prosecutors submit that whether the person surrender or not surrender, it was not really the authority of this tribunal to decide. The co-prosecutors charged Dutch pursuant to the internal rule. In the introductory submission and the final submission and the indictment or closing order by the co-investigating judges, there were no relevant to the facts regarding the law outlawing the DK group. So the defense counsel raised these matters which are opposing, which is different from the facts at issue. We therefore request that the Supreme Court chamber reject such matters being brought before this chamber. Regarding the prisoners released, as stated in the Paris Peace Accord, there were some prisoners who were prisoners of war who have been were released, but for those who committed crimes during the period of 1975 through 1979, crimes falling under the jurisdiction of the ECCC has not been included in that accord. We would like to draw the attention of the Defense Counsel to refer to this Paris Peace Accord, and in particular the preamble part of that accord. The Defense Counsel also referred in their brief when they refer to Article 99 of the Penal Code of 1956. And this is, of course, contradictory to Article 100 of the same Penal Code. As the defense already indicated under paragraph 35 of its brief, that according to Article 99 of the Penal Code of Cambodia, which states that crimes could not be crimes if they were committed under orders, and that the order had been issued by the legitimate authority. The submission by the Defense Counsel gives rise to the question that whether the Democratic Kampuchea regime exercised or implemented any law, enforced any law. The answer is very simple. The regime did not apply any law. The national and international community have been fully aware that the regime killed, starting from killing former officials of the People's Republic before in 1975, while Cambodian people were evacuated from Phnom Penh, and the execution of the former soldiers and officials were killed because they were under the pretext that the American would bomb the cities. And later on, purges were carried out within their ranks. People who were purged were accused of being the ball within enemies. The Nuon Chea was the president of the People's Assembly, and everyone is familiar already that the Assembly is the body to make the law. However, at that time, the People's Assembly did not really enforce or make any law, but they really followed the rules and orders of the DK regime. S21 was established by the DK for the purpose of smashing all the enemies of the regime. Civilians were arrested as well as soldiers also who were caught outside the battlefields were detained. Deutsch indicated that he did not want to elaborate anything on that, even though the Khmer Rouge regime, the Khmer Rouge regime had its legitimate seat at the UN, but later on the Khmer Rouge regime itself has been known by the world that the regime without any law and a criminal organization. The reference to the above articles by the Defense Council, for example, the spirit of Article 100 of the Penal Code of 1956, which states clearly that subordinates who received orders and who knew that the order were illegal, they would not be relieved from being prosecuted. This article links closely to the fact that Deutsch fall within the investigating framework of the context of S21 because Deutsch was quite familiar of the criminal implementation of the conducts of the Khmer Rouge regime, and he was quite familiar with this even when he was at 13. He was familiar with the execution of people en masse and also the removal of right to ownership. Therefore, Deutsch must have known very well about the orders his superior had imposed on him. He shall not be falling out of the jurisdiction concerning the crimes he committed at S21, regardless of his working under duress. According to Article 29 of the ECCC, I quote, "The fact that a suspect acted pursuant to order of the government of Democratic Cambodia or a superior shall not relieve the suspect of individual criminal responsibility." Your Honors, I would like now to proceed further, but would like to inform the Supreme Court chamber that we would like to refer to two documents regarding the Khmer Rouge prisons and the selected Khmer Rouge autobiographies. Since the chamber has already accepted the documents, the prosecutor would like to touch upon on this. We would like to submit that the policy by the Communist Party of Cambodia is to be implemented by the security center. And the security apparatus is the heart, or was the heart of the policy of the CPK in smashing the enemies and smashing those who perceived as enemy. S21 was the most important office in this apparatus. Although evidence did not indicate that S21 played the role to oversee all other security centers across the country, but it is unequivocally clear that S21 was in the highest hierarchy regarding the security center of the CPK, and it has a very unique characteristic. As the co-prosecutor already found some special characteristics as follows. For example, the S21 had to report directly to the center and to met directly with the standing committee as well. And this communication had to be done through with Son Sen and Nuon Chea. S21 was the only party center security office which was tasked with arresting, detaining, interrogating and executing cadres, senior cadres of the Communist Party of Cambodia within the Ministry, Committee and Revolutionary Army of Cambodia and from a zone and other places. The prosecutor would like to refer to the name of some people, important people who were killed at S21, including Won Wade, alias Pinh Thuo, member of the Standing Committee and Deputy Prime Minister in charge of Economy, Koi Thuon alias Thuch, Minister of Commerce, Ho Nim alias Pos, Minister of Propaganda and Information, To Phuen alias Phun, Minister of Public Works, Suh Wasi alias Duen, former head of Office 870 and Minister of Commerce, Nong Suon alias Jay alias San, Secretary of the Agriculture Committee, Chum Sam Auk alias Pang, Office Administrative Office, Chai Kum Ho alias Hok, General Staff of the National Defense, Siet Chai alias Tum, General Staff of the Ministry of Defense, Cheng On, Minister of Industry Ministry, Nay Saran alias San, alias Ja, Secretary of Northwest, Mool Sambat alias Ruh, Secretary of Northwest, Chu Chet alias C, Secretary of the West, Tân Son alias Nham, Committee Commerce, Source, No alias Chu, Kao Kum Huot alias Sot, Chan Chakray alias Prombat, Unlon alias Nat, Ung Sok and Nham Tho. These are the names of the senior cadres who were killed at S21. But other security center did not really oversee such executions of senior people. Regarding the detail of the list of names of prisoners at S21, we may refer already to the list as submitted before this chamber, the trial chamber, and the Defense Counsel also refers to this list as well during the investigation phase. S21 was operated as a tool to smash all the security elements within its rank with the support from Dutch to make arrests and smash any subordinates, several of whom were killed at S21 and Presor. Dutch himself admitted that some Presor prisoners were sent to Chiang Ai to be smashed. Dutch referred to ERN 0006728, which indicated that 17 people were sent to be executed, taking from S27 or Presor to Chiang Ai, and 160 children were also sent to be smashed at Chiang Ai. Without support from Dutch, the superiors would not know what the subordinates could have committed, or they would not be arrested. This proves that Dutch himself was familiar with this, and that his request to his superior would never be rejected. It indicates that Dutch was vested with power to make a decision. It is contradictory to what the defense has indicated, that their client did not have any power to make any arrest or detention. And it is also contradictory to Hum Hoi's testimony, in which he indicated that in some instances the accused himself went to arrest people in person person. S21 was the only security center during the decade that has the scope to cover the whole country. This center provided advice and coordinated the smashes of the people with the administration and other military all across the countries. For example, Dutch met in divisions 290 and 170 to search for the name of about 20 people to be arrested and executed. S21 on top of that received all prisoners from across the country. Furthermore, S21 employed a very broad resources and including the interrogation, detention and torture, and it had employed real organizational chart. The directives had been issued strictly to be obeyed by his subordinates. There were 3 interrogators group, including the cool, the chewing, and the hot ones. And the interrogators were trained by Dutch. Execution was carried through blood drawing, and people were taken to be executed at Cheung Ek through annotation by Dutch. In one of the annotations, Dutch stated, "Uncle Peng smashed them all." S21 was the security center of the Democratic Cambodia that had the most people under its operation. There were 2,327 people working for S21. No other security center had this number of people. Also, S21 received Vietnamese prisoners of war and Westerners who were arrested at the sea. For example, the 3 Westerners who were arrested from the coastal area of Kampong Sound were sent directly to S21. They were not sent to any other autonomous security center. So it is true that S21 had the biggest power than the other security center across the nation. As indicated and as observed, the special characteristics of S21 above, the co-prosecutors submit that the Defense Council have failed to prove any speciality or special characteristic of Chong Choroi security prison. The Defense Council indicated under paragraph 43 of their appeal brief that Chong Choroi was another important security center. It indicated that if Dutch were most responsible for the crimes committed under the framework of S21, other security center would have been also charged or prosecuted. However, if it is according to the submission by the co-prosecutors that they had no bound to prosecute all the head of the security center all across the nation, I'm referring to the 195 security prison, then Dutch should be also free. The prosecutors would like to draw your attention to the submission by the Defense Council with reference to the prison of the Khmer Rouge